Schreiber was hospitalized on March 30th after large kidney stones caused him to urinate internally, which in turn led to him developing septic poisoning. The septic poisoning caused him to fall unconscious in his prison cell. He was transported to a local hospital where he was resuscitated 5 times by receiving adrenaline and epinephrine via an IV. After he was resuscitated, medical staff performed surgery to repair organ damage caused by the kidney stones and treated Schreiber's septic poisoning with antibiotics. He claims he momentarily died at the hospital, thereby fulfilling his life sentence under the first-degree murder sections. Because his sentence has been fulfilled, he argues, he is imprisoned illegally and should be immediately released.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Next, we have something truly unique. I'm not even going to tell you what it is because it's just that fun. It's short and it's fun, and I think you'll enjoy it, and we'll get into a little bit of a philosophical discussion as well. But if I told you what kind of discussion, then you might guess before we got there, and how could I build up the drama then? This is in the Court of Appeals of Iowa, and this is Benjamin Schreiber versus the state of Iowa. This is an appeal from a district court Wapello County decision. Crystal Kronk, judge. What is with the names this morning? Benjamin Schreiber seeks to resurrect his 3rd post-conviction relief application after the district court granted the state's motion to dismiss. We affirm. Affirmed means that the state's motion to dismiss is going to stand, and the 3rd post-conviction relief application is dismissed. Benjamin Schreiber seeks to resurrect his 3rd post-conviction relief application after the district court granted the state's motion to dismiss. Schreiber was convicted of murder in the 1st degree. He was sentenced to life in prison without the possibility of parole. On appeal, he alleges the district court made several errors in the course of handling his PCR application, including 1, denying him a meaningful opportunity to respond by failing to provide him adequate notice of the hearing on the state's motion to dismiss, failing to record the proceedings, dismissing his application without an evidentiary hearing. 2, requiring him to pay 20% of the filing fee of the application, and 3, denying his application for court-appointed counsel. For the reasons below, we affirm. The events forming the basis for Schreiber's application occurred in March 2015. Schreiber was hospitalized on March 30th after large kidney stones caused him to urinate internally, which in turn led to him developing septic poisoning. According to Schreiber's pleadings, the septic poisoning caused him to fall unconscious in his prison cell. He was transported to a local hospital where he was resuscitated 5 times by receiving adrenaline and epinephrine via an IV. After he was resuscitated, medical staff performed surgery to repair organ damage caused by the kidney stones and treated Schreiber's septic poisoning with antibiotics. Can I first say, the man's a prisoner. Why isn't someone treating his kidney stones before it gets this bad? Like, he's under the care of a prison. This isn't what we mean by punishment. He's not supposed to be suffering kidney stones as part of his punishment because they don't take care of him in prison. I don't feel for murderers. I do feel for human beings who are in prison. They have rights, and I wouldn't want anyone to be in prison paying for their crimes and suffering kidney stones because we didn't give them medical care. So there's that. Schreiber filed his application April 2018. He claims he momentarily died at the hospital, thereby fulfilling his life sentence under the first-degree murder sections. Because his sentence has been fulfilled, he argues, he is imprisoned illegally and should be immediately released. The state moved to dismiss, and the district court scheduled a hearing on the motion. Schreiber did not resist the state's motion. He maintains he only became aware of the motion after the district court entered its order granting it. The district court summarized his claims and concluded no further proceedings were warranted. Petitioner asserts that he died on March 30th, 2015, and as a result of such death, he has now served the life sentence and should be released from custody. The court finds this assertion unpersuasive and without merit. Nothing in the record supports petitioner's claims. The petitioner's filing of these proceedings in itself confirms the petitioner's current status as living. After receiving the court's order, Schreiber filed a motion titled Petitioner's Pro Se Motion for Reconsideration. This motion informed the court that Schreiber had never received notice from the state of its motion to dismiss and insists the court violated his due process rights by granting the motion. In response, the district court entered an order setting a hearing on Schreiber's motion for reconsideration on the pleadings only and directed the state to file their resistance with proper notice to opposing party. Schreiber did not submit any documents for this hearing. The district court denied Schreiber's motion and Schreiber now appeals. We review PCR proceedings and summary dismissals of applications for errors at law. Although it did not specify, the district court apparently dismissed the application under Iowa Code Section 822, which allows the court to dismiss an application when it is satisfied on the basis of the application, the answer or motion, and the record that the applicant is not entitled to post-conviction relief and no further purpose would be served by any further proceedings. Schreiber alleges several errors occurred during his procedure, which together amount to a violation of his due process rights. First, he argues he was not given adequate notice, which the district court scheduled after the state moved to dismiss the application. While Schreiber correctly notes that he was entitled to an opportunity to reply to the proposed dismissal, the district court fulfilled this requirement by scheduling a second hearing on the merits of his application after the court became aware Schreiber had not been properly notified of the first hearing. Second, Schreiber claims the district court erred by not recording the hearing on the motion to dismiss, which he claims they were required to do under Iowa law. However, the recording requirement only applies to evidentiary hearings on the merits of the claim. The hearing on the motion to dismiss was not an evidentiary hearing. As such, the district court did not err by failing to record it. Third, Schreiber argues the district court erred by dismissing the PCR application without an evidentiary hearing, which he claims was necessary to develop his claims. We approach motions to dismiss with great caution, and we only grant a motion to dismiss when there is no conceivable state of facts that might support a claim. In essence, Schreiber claims that he died and he was resuscitated by medical staff in 2015 against his wishes, thereby completing his sentence. He asserts that he was sentenced to life without parole, but not to life plus 1 day. Therefore, he is being held in violation of his rights under the Due Process Clause and the 5th and 14th Amendments of the Constitution. We do not find his argument persuasive. He cites no case law that supports his position, and the Iowa law directs the district court to commit defendants guilty of Class A felonies like Schreiber into the custody of the director of the Iowa Department of Corrections for the rest of defendant's life. Because Chapter 902 does not define life, we give its term our plain meaning. Our primary goal is to give effect to the intent of the legislature. The plain reading of the statute is that a defendant convicted of a Class A felony must spend the rest of their natural life in prison, regardless of how long that period of time ends up being, or any events occurring before the defendant's life ends. We do not believe the legislature intended this provision, which defines the sentences for most serious cases of felonies under Iowa law and imposes the harshest of penalties, to set criminal defendants free whenever medical procedures during their incarceration lead to their resuscitation by professionals. We conclude the correct reading of the law requires Schreiber to stay in prison for the rest of his natural life, regardless of whether he was resuscitated against his wishes. As such, the district court did not err in dismissing his application because no conceivable state of facts supports Schreiber's claim. Schreiber is either alive, in which case he must remain in prison, or he is dead, in which case the appeal is moot.
So basically, if you're alive enough to appeal something, then you're alive enough to be in prison?
Yeah. In either case, the district court did not err. So they repeat the statement about being actually dead. As explained above, there is no such issue of law or fact. Schreiber is either still alive, in which case he must remain in prison, or he is actually dead, in which case the appeal is moot. In either case, the district court did not err by refusing to appoint him counsel or to give credence to this death story. So what do you think of that? If you were resuscitated against your wishes, would you feel in a way about it? Like, finally, I'm released from this prison and now I'm brought back to continue to serve my sentence. And I thought we could have a quick philosophical discussion. Like, how do you feel about this treatment of this prisoner? He's a murderer after all.
Even though he's a murderer, I mean, he still has like human rights, and obviously I don't know exactly what he did, but I mean, I feel for him in a way. Like, he did not wanted to be resuscitated, so basically against his will he has to stay alive and stay in prison for when they think it's good enough for him to die, which is probably even just harsher than just having a life sentence. Like, he could have been over and done with everything now, but they had to bring him back.
Yeah, I think that ignoring the DNR is probably some form of assault, but I don't think that gets him out of his prison sentence. Also, if he were to be released, I think that would provide a really perverse incentive for prisoners to attempt suicide or to harm themselves in such a way so that maybe they would have a chance of being released. And I would really not want to encourage that in any way.
Oh, yeah. Just one thing that I just want to quickly throw out there for people to comment on. Like, this morning, like before you guys were awake, I was thinking about the story. And if we look at the biblical terms, we had Jesus who basically was sentenced to death and then released 3 days after still being alive. So should he be rearrested because he didn't actually fulfill his punishment? Or
Hey, if you can find him, I think that'd be a miracle all by itself. So thank you for joining me. That is our show. You are watching Lawful Masses with me, Leonard French, your favorite copyright attorney. This channel would not be possible without your support. We use patreon.com/ljfrench and sponsors.com/law for our community building and support gathering. This month, the November month of giving, sponsors.com is running a promotion where creators will only be charged a 3% fee instead of the standard 7% fee. So if you are interested in getting started on sponsors, now is the time to go ahead and do that. Visit sponsors.com for more information. I am just a creator on the platform. I am not financially interested or invested in sponsors.com myself. Full disclosure. Thank you to our $50 plus supporters on both platforms: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters scrolling on the LED panel behind me, and all of you will be on the crawls at the end of the videos that drop. Happy fall, everybody. I will be working on some things for you this week, and I look forward to dropping the podcast. I believe the podcast has been finished, and Patreon donors and sponsors supporters, and I believe Twitch subscribers too, will all get access to the super secret link that is the podcast, which will hopefully be dropping later today or sometime this week, early on Monday or something. I'm Leonard French, your favorite copyright attorney. I love you all. Have a great week. I'll see you in the videos. Bye.